Hello, my name is Lee Vernon. I'm a San Diego County family and divorce attorney. Additionally, I am a military veteran. I served almost 8 years active duty service with the United States Coast Guard. Helping veterans, active duty service members, and reservists when they're going through difficult family law issues here in California is something that I'm incredibly passionate about. Today I'm going to focus on the issue of child custody and visitation under the military lens. I'm going to talk about one recent case that I've had called a move-away case. A move-away case is a child custody and visitation case where one parent is seeking a court order to allow them to move out of either San Diego County or sometimes out of the state of California. So in a move-away case, the paperwork that is required to be filed is just the same as if you're filing for a regular custody and visitation order when both parents live here in San Diego. But the difficulty with the move-away case is that the court has to make a decision, and often a very difficult decision. And your military service, if you're an active duty service member, can complicate the situation, because we all know that although you might be stationed here in San Diego, you probably won't be able to be stationed here in San Diego indefinitely. So you may be transitioned from San Diego to the East Coast, or from San Diego to Germany, or San Diego to Japan. So one recent case that I had, the parents were a military family, and the father was restationed on the East Coast, and a custody and visitation order was made right here in San Diego County. The order specifically said that the children had to remain residents of San Diego County unless both parents could agree in writing or a court ordered one parent to be allowed to move with the children. So in this case, I represented the mother. The mother wanted to move from San Diego to the East Coast, and the father was in a different state on the East Coast. So they were not going to be close enough to really realistically be able to share joint physical custody or to allow one parent to have almost equal time. So what happened in this case, the court had to consider that the parent who was requesting the move, the mother, out of the state, was going to move. They also had to consider the impact that that move would have on the father's relationship if the children were allowed to move with the mother. And just by default, if you're an active duty service member and you have your significant other is a stay-at-home parent, that parent is establishing themselves as what would be known as the primary caretaker of your child. And the younger that your child is, it is more difficult to convince the court to take away the primary caretaking role from the stay-at-home parent. And so in the case that I'm talking about, ultimately the mother had established herself as the primary caretaker. The father was a great parent. There was nothing wrong with his parenting, but unfortunately they were divorced and the court had to make a difficult decision. And ultimately the mother was allowed to move out of state against the father's wishes simply because she had established herself as the primary caretaker. And again, I want to make it clear that one of my biggest passions is to help out military veterans, active duty service members, and reservists if you're going through a difficult family law issue. I offer free monthly seminars right here in San Diego. Go to www.leevernonevents.com to learn more about my next upcoming event.